Well, good afternoon, everybody, or good evening, good morning, depending on which time zone that you're in at present. My name is Dr. Richard Cadell, and I'm a senior lecturer in marine and environmental law at Cardiff University, and the editor-in-chief of the Journal of International Wildlife Law and Policy. Submissions welcome. And I have the great honor today of moderating this particular session. So as you'll be aware, this is the 7th webinar in a 10-part webinar series on international biodiversity law post-2020, which is part of the 17th edition of the United Nations Environment Programme, University of Eastern Finland course on multilateral environmental agreements. So just a little bit of housekeeping before we start. You'll see at the bottom of your screen there is a Q&A box. I think we're all seasoned Zoom users at the moment, but I think this is still a welcome tutorial. So you'll be able to post your questions in the Q&A box for Arie later on this particular session. So without further ado, it's a great honor and pleasure to introduce Dr. Arie Trouwborst. And really for those that have been engaged with international wildlife law over the course of the last 10, 15 years, Arie probably requires very little introduction, and his name will be a very familiar one from the author's masthead of a number of the most innovative and interesting and insightful legal contributions on the protection of global biodiversity across both the legal and indeed the scientific literature. But anyway, Arie is an associate professor of environmental law at the University of Tilburg in the Netherlands, and has a particular interest in biodiversity law at the international, European, and national levels, particular expertise in conservation, restoration, and sustainable use of biodiversity. And in addition to his academic work, Arie regularly advises many international organizations, notably the Berne Convention on European Wildlife, the Convention on Migratory Species, and the IUCN, as well as many national governments and non-governmental organizations on wildlife law. And as academics, we're often accused of taking our work home with us. Well, Arie is particularly well placed to do so as a qualified animal tracker, although given that much of his recent work has involved some of those species that are arguably the reddest in tooth and claw, that's probably not the best of ideas to be doing. In recent years, Arie has challenged us to look afresh at international wildlife law, and a number of his recent works have really exposed some of the fault lines in international biodiversity law. He's challenged us to look away from this idea of deathbed conservation that's traditionally associated with species protection. He's also challenged us to perhaps look at the role of our pets in biodiversity management, with a very interestingly received paper on the regulation of domestic cats. And more recently, in the Journal of Environmental Law, you can see that he's challenging us again to look afresh at how we think about ecosystem restoration, rewilding, and other elements of the international biodiversity system. The title of Arie's talk today is The Prospects of International Wildlife Law, and I'm sure that as we go into a period of seismic change and major milestones in the various biodiversity treaties, this is a wonderful opportunity for reflection on these issues with one of our leading experts. So without further ado, Arie, it's my pleasure to give the floor to you.
Thank you very, very much indeed, Richard. After these glowing words of introduction, let me see, I'm just going to share my screen, one thing at a time. I hope you can all see my first slide now. Right. So here we go with indeed, as Dr. Cadell said, the prospects of international wildlife law, quite a broad scope for a topic to be dealt with in less than an hour. And here's this beautiful introduction that really sketches the breadth of the topic I was invited to reflect on and exchange thoughts with you. Achievements in the past, limitations, future challenges, and especially after the very, very kind words of introduction, this talk is absolutely bound to disappoint you. So I'm just lowering the level of expectation again, as you can see. And also, before really starting off, I want to make sure that all of you realize the privilege that it is to have Dr. Cadell chairing this session, and just trying to achieve a little bit of balance here. So he has published a lot on marine mammals, for instance, is the foremost expert on the Convention on Migratory Species, working on a much eagerly awaited book. Publishes in Science as if that's a normal part of a lawyer's job, and is also well known for his wildlife ties. In these pictures, you can see a tie with flamingos and zebras if you have a large screen. And this is a webinar, and the biggest advantage, next to many disadvantages of webinars for the speakers, is that you only have to worry about dressing a good appearance of the upper half of the body that will appear on camera, right? So I'm wearing very old jeans now and Crocs, and Richard is also familiar with this advantage. And I'm not trying to undermine your authority here, Dr. Cadell, as moderator. If anything, this is going to boost your reputation. So, on the menu today is international wildlife law. I'll begin with speaking a few words on what I understand by international wildlife law. And then the three main pillars of the talk are the achievements of international wildlife law, its limitations and challenges, and there's an element of past, present, and future there. Of course, in less than an hour, we can only briefly touch on these issues, and I will try to achieve a balance between some general reflections on achievements, limitations, and challenges of international wildlife law, and some concrete illustrations, some of these on topics that I'm personally familiar with. And of course, it's inevitable that I'm going to say some very obvious things when dealing with this topic, but I'm going to say them anyway, because if we're going to address the prospects of international wildlife law, we cannot go around these. And I'm very much looking forward to the Q&A at the end of the session. So international wildlife law, as I understand it here, is the body of international legal instruments that are specifically aimed at the conservation and/or sustainable use of nature / wildlife, biodiversity, fauna and flora, natural areas, ecosystems. And of course, we should not forget that we're not just dealing with binding pieces of paper here, but that these international legal instruments very often have institutions that regularly meet, that carry out all kinds of tasks, that most of these conventions are indeed embedded in broader organizations, such as the CBD, the Convention on Biological Diversity, within the UN Environment Programme, the Berne Convention on European Wildlife Conservation, which is operating within the framework of the Council of Europe, and then there's the EU Birds and Habitats Directives, binding EU legislation for nature conservation, operating within the broader legal and policy framework of the European Union. If we take a bird's eye view of this topic, of this area of law, international wildlife law, we first of all see a number of global instruments, particularly conspicuous ones being those that are sometimes referred to as the Big Five global conservation instruments, the Ramsar Wetlands Convention, the UNESCO World Heritage Convention, the Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES, the aforementioned Convention on Migratory Species, the CMS, the Biodiversity Convention. But apart from those, there's a plethora of regional instruments, some of them with a broad scope on wildlife conservation in a particular continent or region, such as the African Conventions on the Conservation of Nature and Natural Resources, the aforementioned Berne Convention and Birds and Habitats Directives. And in addition to that, there are quite a few species-specific treaties focusing on a particular species, such as a polar bear, or a set of species, gorillas, or a large set of species, such as migratory water birds in a particular region. Some of these are CMS subsidiary instruments, others are standalone agreements. So just to make sure that we bear in mind that this is a very rich and very diverse landscape, composed by and large of ad hoc instruments. The table here with the overview is from a paper published in Bioscience in 2017, which is co-authored by about 10 lawyers and 10 biologists. And Richard Cadell and I are among the lawyer authors in this paper, where we look very much like today at general features of international wildlife law, weak spots, strong spots, achievements, challenges. So we're looking at this first big topic, the achievements, past achievements of international wildlife instruments. Then the word effectiveness, of course, pops up on the radar. How effective are these instruments? How effective is international wildlife law in general? I get that question a lot, understandably, from students in particular. And so one general observation that is as obvious as can be is that all these international wildlife law instruments that have been negotiated, adopted, and implemented over the past century have not averted the current biodiversity crisis from unfolding and from worsening on their watch. Of course, conversely, I do think a good case can be made for many instruments in many areas that particular species, particular natural areas would have been worse off without these instruments. And so it's hard to generalize, basically. And effectiveness can be understood in many different ways. Procedural effectiveness, effectiveness really on the ground in terms of what has it done to the conservation status, to population trends of particular species. And a lot has been written on the effectiveness of international wildlife law. And typically there's this mix of achievements on the one hand and limitations and failures on the other. To take just one brief illustration, the International Convention on the Regulation of Whaling, with the primary decision-making body being the International Whaling Commission, that's been a mixed bag. You will all, many of you, if not all, will be familiar with the failure of the International Whaling Convention to attract all the right relevant parties to become bound by this regime. The exceptions, loopholes, that particularly scientific whaling, that has impacted the influence of this convention on whale sustainable use and conservation. So in this quite recent book, nice, small, recent book, if you're looking for a pocket size, lightweight introduction into international wildlife law, this is a nice recent edition by David Stroud, Melissa Lewis, and other authors who are really familiar with these instruments from the inside and explain it to a broad audience. And regarding the International Whaling Convention, the authors say, notwithstanding the historical failure of the International Whaling Commission to regulate whale catches sustainably from the 1940s to the 1970s, so the first half of its operation, there is no doubt that without it, many of the great whales would now certainly be biologically rather than just commercially extinct. So really showing the two sides of the coin. And when lawyers like me think about international wildlife treaties, we have the tendency, I certainly do, to primarily zoom in on what are the legal obligations laid out in this instrument, how must they be interpreted and applied, and to what extent can compliance be enforced. And of course, this is part of the way in which international wildlife law impacts ultimately conservation on the ground. But there are many more dimensions that lawyers at least often forget or have a blind spot for, such as the platform for cooperation between governmental and non-governmental stakeholders to get around the table regarding the species or conservation issues involved, and that indirectly influences conservation on the ground. These conventions often are hubs of information and expertise. They develop guidance, non-binding technical guidance that is then implemented on the ground, even if there's no hard obligation to do so, but still impacting conservation on the ground. Also, the priority function of these instruments is well worth emphasizing. So they serve as a moral compass for national authorities and societies, and particularly they keep conservation on the agendas. So these conferences of the parties that occur every 2 or 3 years, depending on the treaty involved, can of course be criticized for being perhaps a waste of resources, of traveling around the globe and so on. But they do periodically keep this issue on the agenda. When this COP takes place, such as now the climate change summit in Glasgow, it's all over the press. So because of these regular conferences of the parties, it's hard for governments to completely ignore the issues that are addressed by the treaty, even if they aren't addressed in terms of splendid, strictly formulated, hard binding obligations in all cases. And so the past impacts of international wildlife instruments are manifold. An important first thing to note is that many protected area designations have occurred as a direct consequence of international legal regimes calling for such designations. So either that can be new protected areas, such as many of those were established in the wake of the 1968 Algiers African Convention for Nature Conservation. So quite a direct link between that convention and the subsequent designation of protected areas in the parties to that convention. The Natura 2000 sites in the EU are another good example. World Heritage designations, Ramsar Wetland of International Importance designations. All of that adds layers of protection to the areas involved. Same is true for national legislation regulating the exploitation of certain species as a direct consequence of these international wildlife regimes. Enhanced priority, non-binding guidance documents that then impact conservation on the ground. Funding, hadn't mentioned that yet before. And of course, last but not least, many instances in which harmful developments were blocked or particular specific conservation actions taken when governments were confronted with their international obligations in court proceedings or compliance mechanisms. That's again from our bioscience paper. A very concrete example where biologists have detected a one-on-one relationship between international obligations under, in this case, the Convention on International Trade in Endangered Species and the conservation status of species. In practice is South American cats, such as the jaguar, where you see the skin displayed on this slide, but also ocelot, margais, and other cat species, wild cat species, where the study found that the placing of these species on Appendix 1 of CITES with, as a result, the commercial trade ban, by and large, imposed by CITES on trade in skins of these cats resulted in a notable increase in population trends, conservation status of the species involved. Just checking that you're still awake. Lions is the next species we're going to look at for a moment. So It's a thrilling experience to, Richard already alluded to this in his introductory remarks, a splendid experience to be present in areas where a species like lions is around. It makes you humble and small as a human being. And I've had the privilege of being in that situation quite a few times. And this is a lion paw print. And just to give you an impression of the size of that paw, you see my wedding ring at the right bottom of the picture. Here it is. I use that one a lot, despite some objections from my wife to take the measure for the picture of these pictures. It has a diameter of exactly 2 centimeters, which is very convenient. But this experience can be had in less and less and less areas. So lions used to be one of the most widespread mammals on the globe. There were lions in North America, all across Eurasia and Africa. Nowadays, this is very, very different, as this book by Keith Somerville documents very well. The history of humans and lions has been quite a one-sided one, in which humans have had the effect of driving lions away from more and more and more parts of their natural range, and now they are confined to quite small areas of Africa and one small area in India. And there's about 30,000 lions left in the wild, researchers estimate. And to give you an impression of how little that is, the stadium of the Bluebirds, the football team of Cardiff, that stadium seats about 33,000 people. So there's more people that can find a seat in the Cardiff City Stadium than there are lions in the wild. So what's law got to do with it? That's the question we asked. We being Melissa Lewis and myself from Tilburg University, and a group of biologists with expertise in lion conservation from the Wildlife Conservation Research Unit from the University of Oxford. We teamed up to try to get a global grasp on the relevance of international law, international wildlife law, for lion conservation. And here's an overview of relevant global and regional treaties for the lions in Africa. So there's the Ramsar Wetlands Convention, protecting 39 sites, not primarily for lions, but for their wetland value and wetland species value, but nevertheless many large areas that also are home to lions, and the lions then profit from the protection endowed on those areas by the Ramsar Convention. And there's the World Heritage Convention, similar story, 18 listed sites with lions. Then the lions are in Appendix 2 of CITES, meaning that trade is regulated. They are also more recently listed on Appendix 2 of the CMS, meaning that range states that are CMS parties are called on to coordinate conservation efforts for shared lion populations. And there's various other international instruments of direct or indirect consequence for lion conservation. Just to look at the World Heritage example, just to get a more concrete grasp of what this potentially means. So these 18 sites in 13 African countries protect millions of hectares of lion habitat. And the Serengeti National Park is one of those, because then of course the question is, does that really make a difference on the ground? Well, the answer again is it depends. Sometimes it fails to do so. Sometimes it has a decisive influence, and everything in between. So when we look at the example of the Serengeti in Tanzania, there's a very concrete example that shows the potential value of a convention like the World Heritage Convention for wildlife conservation on the ground. And this involved the plan by the Tanzanian authorities to upgrade a road running through the Serengeti National Park into a Serengeti super highway. Now, of course, that would have quite big consequences for the Serengeti ecosystem, including the lions, depending on the migratory wildlife that has to cross that area periodically. And so the UNESCO World Heritage Committee strongly urged Tanzanian authorities to not go ahead with this plan because of the effects it would have on the value of the World Heritage Site. And concretely, this became a case before the East Africa Court, so the court established under the Treaty for the East Africa Union. And the court ruled that the plan to build this highway would be a violation of Tanzania's obligations under the East Africa Community Treaty, the general obligation of environmental protection laid down in the treaty. And to reach that conclusion, the court emphasized heavily that this is a World Heritage Convention site, a World Heritage site, and that the obligations of Tanzania under the World Heritage Convention influence the interpretation of the other East Africa Treaty obligation, with the result that building the highway would be against Tanzania's international obligations. So the World Heritage status seemed to be a decisive factor in the East Africa Court ruling that Tanzania was not allowed to build this super highway. Very concrete example. So that's about achievements. Limitations are next. Basic conditions for effectiveness of international wildlife instruments are at least these three. So if you want to regulate effectively a particular threat, address a particular threat to wildlife, then you need to attract a sufficient number of the parties that are relevant to this issue. But also you want clear and adequate commitments for those parties. And you want a sufficient degree of compliance with those obligations. And then this is, of course, a balancing issue, because if you include very stringent obligations with no escape clauses, then you can expect very few parties, vice versa. So as Stroud and others have put it in their book, most conventions present an uneasy compromise between what is environmentally desirable and what is politically feasible. And this has resulted, this need for compromise, for instance, in the phrasing of the CMS's Article 34A for Appendix 1, migratory species. For these species, parties shall endeavor to conserve and, where feasible and appropriate, restore those habitats of the species which are of importance in removing the species from danger of extinction. Endeavor, feasible, appropriate, all of those you can well imagine open doors for discretionary judgments by the parties involved of what they consider to be a sufficient endeavor, what they consider to be feasible in their circumstances and appropriate. Same is true for many obligations in the Convention on Biological Diversity. For instance, Article 8F, each contracting party shall, as far as possible and as appropriate, rehabilitate and restore degraded ecosystems and promote the recovery of threatened species. Now, of course, where the science and the policy on in this case, ecological restoration is unclear, then the possibilities for states to hide behind these terms is greater. But these terms don't mean that these are somehow soft, meaningless obligations, especially now. The level of urgency and clarity and scientific basis for the need for ecosystem restoration that is achieved now, today, and as documented by the IPBES, as reflected in the fact that we are in the UN decade of ecosystem restoration, all of that suggests that massive scale ecosystem restoration nowadays is highly appropriate by default. And so it would be for states who are reluctant to do this to show that it's not appropriate. So interpretation will play a key role in what these obligations mean in practice. We talk about limitations. There's all kinds of ways in which these limitations show. For instance, in terms of gaps. In some parts of the world, there is not a dedicated regional wildlife law instrument. So complete instruments can be lacking. Participants is another typical gap. If we look at the little map of CMS, parties currently see that a lot of states in South America, Africa, Europe, and a part of Asia are parties to the CMS, but that there are big gaps, North America and East and Southeast Asia in particular, where many states have not become parties to the CMS. And that obviously affects the influence of the CMS in concrete terms. And there's gaps in terms of species and sites, particular blind spots, typically in species lists for invertebrates, insects, plants. Emphasis tends to be on more charismatic big mammals. Some instruments lack institutions and become sleeping treaties in that sense. They don't have these regular meetings, and these instruments become asleep in that sense. And there's clashing approaches. Just think of CITES, conferences of the parties, with the increasing difficulty of groups of states meeting each other in terms of the moral values that they take as their starting point for regulating international trade. No use versus sustainable use, to put it simply. That affects the effectiveness of these regimes to take decisions on species and issues that arise. Typical resource gaps, of course, particularly in developing countries, and compliance gaps. The picture on the right is of me in the Kruger National Park with a wire snare that we just came across when we were doing a guided bushwalk. So this is one of the most famous, important natural areas, relatively well organized, relatively well protected, and still there on a bushwalk, you come across snares put there illegally to capture and kill wildlife, illustrating compliance gap. As our moderator already stressed, domestic cats are another very vivid example of a blind spot when it comes to complying with international wildlife regimes. It's well known that domestic cats, when they roam free outdoors, kill millions and millions and millions of vulnerable wildlife day in or year in and year out. And so if you look at international wildlife law, there are many obligations that actually right now oblige governments to do something about this problem, but virtually all of them are looking the other way for various reasons. That's something else we might discuss in the Q&A if you're interested and if there's time. The bottom line is very well documented in the recent IPBES reports, including the Global Assessment Report on Biodiversity and Ecosystem Services. Yes, biodiversity is rapidly declining. There's the typical 5 human-made threats of habitat loss, overexploitation, pollution, climate change, and invasive alien species. But importantly, we also know very well how to protect nature, and this is eminently possible if the political will were there. And so this is another quote from that bioscience paper saying just that. Essentially, international law cannot accomplish more than what the world's diverse and changeable national administrations and ultimately the societies they represent, you and me, want it to. And just yesterday, Sir David Attenborough had this speech in Glasgow where he said something along these lines that in my lifetime, he's 90 something, I have witnessed a terrible decline. And in yours, you can witness a wonderful recovery. And that is the case on the basis of the available science. If the political will is there, restoration can happen on a massive scale. So when looking finally at the challenges into the future post-2020, basically what we've discussed so far answers the question what the challenges are. So what must be done to get restoration well on course is to consolidate and build on the achievements that have already been achieved in the past by these wildlife instruments and address their limitations that hamper them from being more effective. Of course, that sounds very easy. It isn't so easy in practice, of course, but it's possible. I've listed a few more concrete challenges here that we also might wish to discuss in more detail later on in the questions, if you wish. So there's the issue of intra-generational equity, so solidarity, in particular between developed and developing countries. In the developed world, in most countries, wildlife has been depleted in the distant past to very low levels, and still the societies of those countries often silently assume that societies in developing countries that still have much more complete nature around will do their best to conserve them. Big issues arise there, obviously. There's the clashing approaches that I touched briefly on before. This climate change as climate changes, temperatures rise, rainfall patterns change, wildlife tries to adapt to these changes. And then, of course, they will start to move around, or to try to move around, to keep track of favorable conditions. But protected areas are fixed in the landscape in most cases. The regimes for the sustainable use of fish and other marine resources, as Richard Cadell has written about, those regimes have their fixed areas. So they will have to cope, all those legal instruments dealing with these issues will have to cope with these species that are increasingly on the move because of climate change. And then there's the big question of integration. There's a very nice integration principle in the Rio Declaration already, always considered a part of the notion of sustainable development, that environmental concerns are integrated into all relevant areas. But still in practice, the typical situation is that we have wildlife instruments, whether it's at international or national levels, and we have fisheries instruments, we have agricultural regulations and policies, and in these fisheries and agricultural and forestry policy and law areas, wildlife is not well integrated still. So that remains a huge challenge for international wildlife law for the future. And an elephant size challenge is restoration, already mentioned a few times before, and rightly so, because this will be the big one. Right now, biodiversity is very depleted. The only way is up. And so more space will have to be created for nature if the biodiversity crisis is going to be addressed and reversed. And this also means restoring the right conditions, including natural dynamics in areas, and restoring missing species that played key roles in ecosystems and have disappeared and should come back one way or another. And to wrap up, I'd like to give you one hopeful example, namely wolves in Europe. This flat surface is a bicycle path in the Netherlands, a path where I ride my bike very often, and the object on the road is a wolf turd. This is a very vivid sign that wolves are back even in the Netherlands. So in the past, wolves used to live everywhere in Europe. The gray map shows their distribution. Then the red map shows where wolves were driven back to. They disappeared from virtually the entire continent. And now they are making a comeback. They're coming back into Scandinavia, coming back into Germany, even the Benelux countries, coming back into France. And that has a lot to do, not only, but it has a lot to do with the protective legislation at European levels. Particularly, there's a big difference between how wolves are doing in states where the Habitats Directive of the EU applies and countries where it doesn't, such as Switzerland and Norway, where wolves are really struggling to get a foothold, where there are very, very lenient policies for killing wolves, Whereas in Sweden, for instance, Norway's neighbor, when the Swedish government tried to limit the comeback of wolves, immediately they got a visit from the European Commission, which is the watchdog of EU nature conservation law, saying this policy is contrary to the Habitats Directive and will take you to the EU court if you don't give space and welcome those wolves. And then they did. And here you can see some images taken in the woods not far from where I live in the Netherlands of a wolf pack, 8 wolves strong, I believe. And when 40 or even 30 years ago, people would have suggested that wolves would return to the Netherlands, people would have said you're a bit silly, because that is of course not going to happen. And it's happening now, and EU law has a big role to play. Here's the final proof that wolves are back in the Netherlands. You see the little windmill there. And so wolves in the Netherlands are a success story of European wildlife law in this instance. There's various limitations, even in country like the Netherlands. Wolves have the first case of an illegally killed wolf, as you see in the last picture on this slide, has just happened. This was just 2 weeks ago. And I see that I should be wrapping up. Final statement here. The European Parliament, where I was invited to be part of a public hearing about wolves. The questions there really drove home that there are many people in European constituencies that are not so happy about wolves coming back. And there were all these questions of, shouldn't we make it more easy to kill wolves? Shouldn't we make it legally possible to have no wolf areas and so on? So yes, many future challenges also in this European wolf instance. Time is up. More about restoration law, I just wish to highlight in 2 weeks from now, something I'm also looking forward to, but it's high time for the Q&A. So I'm happily hand over again to Richard Cadell.
Well, thank you very much indeed, Arie, and a very rich and insightful presentation there. And I very much hope that the wolf populations haven't been as dwindling as the populations of spectators at the Cardiff City Stadium in recent months. Anyway, I'd like to open up the floor for some questions. There's some coming in thick and fast into the Q&A box. So I think the point that you raised at the end there about ecological restoration, and indeed the topic of our next webinar from Anne, is really to look at some other issues associated with this, and in particular habitat fragmentation, which is of course a really significant issue in any kind of joined up approaches to international wildlife laws. So an interesting question here. The issue of habitat fragmentation, as you pointed out in the Serengeti Mara ecosystem, is a cross-cutting issue among many instruments, including the CBD, Ramsar, World Heritage Convention, and CMS. Do you think that the existing legal framework covers habitat fragmentation and ecosystem connectivity adequately?
Thanks a lot for that question. This is indeed a question that is becoming more and more important for several reasons. One is that human activities are becoming more and more dominant in landscapes. So you have this infrastructure, new roads, new railways, new canals, also fences along international borders that are going up to stem flows of human refugees, for instance, that then have the side effect of blocking migratory wildlife in their tracks. And then climate change is adding on to this. So in addition to typical moving species, you get all these climate migrants that would have been very happy to stay where they were if conditions hadn't begun to change, and now they also have to look for space elsewhere. So yes, it's a huge issue that will, the importance of which will only keep growing. And by and large, I believe the wildlife law instruments that we have now were not written with this issue so much in mind. Especially climate change has come later on the international agendas, and so it's a very good question to ask to what extent these instruments are climate proof in that sense. I guess the answer varies from one regime to the next. Generally, these instruments are actively coping with this issue, so adopting resolutions and recommendations, directing parties on how to deal with this, trying to be flexible about legal concepts that might be too fixed or too rigid, and trying to take active measures to enable this migrations and other types of species movements. I don't want to take too much time for an answer, but this could easily fill the last 15 minutes. A very important issue.
Absolutely. Thanks for that. So don't worry, we got plenty of other important issues for you as well. And another intriguing approach to international wildlife law is the possibility of taking rights-based approaches. So what are your thoughts about adopting a rights-based approach to addressing biodiversity loss? So that allocating, very clear justiciable rights to wildlife species in the way that they are to natural and indeed legal persons could be a way forward to improve compliance.
Wonderful questions, firing really big ones. I like it. So rights of nature, rights of species, very rich topic that will be at the forefront, I think, and is already at the forefront of thinking about the future of these legal regimes. And again, let's see. So on the one hand, I would think there are very good reasons to take these approaches seriously and to try to give them hands and feet in a legal sense. And you see some so in international wildlife instruments, it's very difficult to find anything resembling an explicit right of a particular species to its habitat or a right not to be killed. But more indirectly, some of these instruments reflect this kind of thinking. So if you look at some of the instruments under the CMS, the subsidiary instruments, for seals in the Wadden Sea, for instance, the exceptions that allow them to be killed are really almost amounting to nothing. It's just euthanasia in cases of suffering. But other than that, you can't really legally under that instrument kill a seal. So you might say that reflects a strong version of the right to life of those seals. It's pushing the issue a little bit, but there's something to work with in these instruments. Gorillas are a very interesting one as well. The gorilla agreement also allows for no exceptions to the taking prohibition of gorillas. So this is a pretty absolute recognition of the right to life of gorillas, if you wish. It doesn't say it in so many words, but it could reflect partly that kind of thinking. On the other hand, I also see problems on the horizon if rights-based approaches would take explicit form and are going to be pushed in the implementation of these agreements. Not in all cases where the instrument, of course, for instance, is focused on sustainable use of species, just allows or promotes sustainable use, including consumptive use of species, then it becomes more difficult to talk of the right to life of those species. And an emphasis on the rights of individual wildlife, could impair the implementation of approaches that currently are incredibly effective in wildlife conservation of populations overall, particularly in countries in southern Africa, Namibia, South Africa, Botswana, Zimbabwe, where hunting is very much a part of the wildlife economy. And many natural areas are deriving their primary source of funding and their really the justification of their existence as a natural area from the regular inflow of money from trophy hunters from abroad. So if you say the wildlife, the lions and the leopards and the rhino in those areas have an absolute right to life, you can't kill them anymore, then you risk those areas, the habitats, the rhinos, every other critter that shares those areas from disappearing altogether and the area being converted into croplands. So it's going to be a nuanced way forward, I guess, with this rights-based thinking, very much context dependent. So if the primary concern right now is populations, which I believe it should be, and to stem species extinctions and so on, then probably the emphasis should be, in cases of doubt, on anything that works to keep populations in a healthy state, to help them recover and so on. That would be my, my again, too long answer to this question. Thank you.
Super, thank you, Arie. Wondered if we could change tack a little bit now, and if you could please speak about Indigenous achievements, limitations and challenges that you see in international wildlife law. I think one of the things that international wildlife law is often criticized for is this sense of imperialism within it. And so perhaps you could talk a little bit about how Indigenous stewardship and Indigenous approaches could have a role to play here.
Yes, thank you. Yes, so international and national wildlife law in many parts of the world have this imperialist, colonialist legacy in the background. But more recently, the inclusion and participation of indigenous peoples is very much encouraged in all of these wildlife law regimes. The participation of indigenous peoples, learning from what they have achieved. Of course, if you look at exceptions for taking in international wildlife instruments, then a typical exception is also subsistence use. So accommodating for the needs of indigenous peoples and enabling them to keep living and hunting in their traditional ways. So there's many kinds of ways in which indigenous cultures, indigenous knowledge comes into play. Again, very, very rich and multifaceted issue.
Excellent, thank you. And I think just sort of on that point, we've got a couple of questions regarding sustainable use on the one side and conservation on the other, and the tensions that we have within that. And a couple of excellent questions as to, could you speak a little bit about the issue of how sustainable use versus conservation and restoration is accommodated? And there is sometimes a bit of an uneasy relationship between the mentalities of particular treaties on this, and about how this divergence between sustainable use and no use countries might be able to become, might be able to be overcome, if at all it possibly can be.
Yeah, that's another very big one. So of course the CBD. So on paper, everybody seems to be on board with the idea that what we are striving for as an international community is conservation and sustainable use and equitable sharing of benefits from biodiversity. So virtually all states in the world have adopted, have okayed this, these overarching objectives, including sustainable use of biodiversity. And a very good or bad, actually, example where these approaches are really starting to clash is CITES, as already touched upon briefly before. At the latest conference of the parties, a sizable group of Southern African states made a joint statement along the lines of them really starting to doubt whether there are still continued benefits in staying contracting parties to CITES. So that's really crisis mode. And that really is because of the frustration that has been building up among those countries over the issue that from their point of view, they're saying, well, we are doing sustainable use approaches, including consumptive sustainable use, and that's working. Look at what populations of wildlife are doing in Southern Africa. They're going up. And Compare that to places where strict hunting bans have been implemented, like Kenya, where populations have gone down since then, since the 1970s. So, but still, these countries are limited in their extent to which they can benefit from the population that they conserve because of decisions adopted in a CITES context by a majority of parties that they're outvoted by. That limits their possibility of internationally trading those species and benefiting them and using the profits again in conservation, ideally. So they are becoming very frustrated with, especially when the parties in their voting are evidently going against the best scientific advice on what they should be voting, because then it becomes painful, such as with the giraffes addition to the CITES appendices, where the Secretariat and Traffic and IUCN, so all the official advisors, said, parties, we advise you not to include the giraffe because trade has very little to do with the threats to the giraffe. Quite the contrary, in the places where they are being hunted, they are doing well, and conversely. But still, under pressure of predominantly Western NGOs, parties, majority of them were convinced to vote for including the giraffe and presenting this as a conservation success. And now the Southern African countries have to deal with an added layer of bureaucracy also for the giraffe. So that's just an illustration of where it's not turning out to be possible to work constructively on these issues.
Super, thank you. Good time for a couple of final questions, and one that's that's kind of a variation on a theme is one of the problems we see with international wildlife law, in essence, is that political will is a real problem. So how do we get around that problem, and might there be some merit in using the sort of agenda type of litigation for wildlife protection, which kind of forces governments to do more and therefore bypasses that political will issue?
Yeah, thanks. So yes, you see that national courts can sometimes achieve quite a lot when it comes to pushing reluctant governments in the right direction, let's say, from the point of view of biodiversity conservation and restoration. Of course, at the international level, options for doing so are quite a bit more limited because of the way that the system has been set up, and the fact that the priorities are also reflected in the compliance area. So the basic comparison between international economic law with its World Trade Organization, this binding dispute settlement system, with all these wildlife treaties that don't have such systems. There's no international wildlife court that has compulsory jurisdiction. And that reflects probably the priorities of states when they concluded these agreements. And so, yeah, expect things at the national level, depending on the countries involved, not so much perhaps at the international level, I would guess.
Super, thank you. And I think one final question in relation to essentially dynamic management. And we see that climate conditions, and given where we're at with this week with COP26, that the climate is going to have major implications, not only on species movements, but also species habitats. So is it possible that we might consider thinking a little bit more creatively about temporal natures of protected areas and reviewing protected areas for their utility and whether or not we can change those boundaries in the future?
Yeah, great issue. All kinds of creative solutions are possible if we want them. But the law allows for many creative solutions, such as temporary protected areas. Those are also called for already explicitly by the Conference of the Parties of the CMS, for instance. So yeah, anything's possible.
Thank you very much. I think anything is possible is a good way to end things, especially as we get into the difficult negotiations on climate and a major year next year with milestone achievements for the International Wildlife Law Treaty. So I think with that, we'll draw things to a close. I'd like to thank everybody for their attention, for their questions, especially to Arie for such a rich and illuminating discussion and a real deep dive into the wildlife law treaties. To point out as well, that's of course the YouTube channel of the University of Eastern Finland does make these available, so you can go back and watch these at your leisure as well. And with that, the next seminar is also available to be signed up for as well. So I'd encourage you to do that too. But with that, I think I'll bring affairs to a close, and thank you everybody for your attention and your insights.
Thank you, Richard.